Okay, good morning, everybody, and welcome to the final day of the Maine Parent Federation and Gear Parent Network Collaborative Annual Conference. Maine Parent Federation is a nonprofit we're the Parent Training and Information Center for the state of Maine, as well as the Family Health Information Center for the state of Maine, and we assist families to navigate all systems of care when you have a child at home with a disability or special health care need. Gear Parent Network is also a nonprofit organization which specializes in mental health resources, information, and referrals, and they assist all families who have individuals or children at home with a diagnosis of a mental health diagnosis or social emotional diagnosis. Today, I'm happy to welcome the attorneys for law, Atlee, Reilly, and Ben Jones from Disability Rights Maine, our protection and advocacy society in the state of Maine. And we're going to be talking about compensatory education as we look to get back into some in-person learning, hopefully in the fall of 2021. So I want to let you know that we are live streaming on Facebook. We are also recording this webinar and we'll have it available on our website. Atlee and Ben have agreed to make the slides available to us, but we'll probably wait about a week to make those available because we anticipate some guidance coming out of the Office of Special Education Programs, and they want to make sure that the information you receive is the most updated information. So the slides may be delayed for about a week, but we will put the webinar up hopefully by the end of this week on our website as well as on our YouTube channel. If you have any questions, I'll be monitoring the chat box, so please feel free to use that chat box. Your questions may not get answered immediately, but we'll make sure that we monitor the chat box and do get the question answered during the webinar. There is a brief poll at the end, so I would ask if you do have the time to complete the poll at the end. That would be wonderful, as both our agencies are nonprofits, and providing feedback to our funders is what helps to keep our programming free for all of you. So with that, I will turn it over to both Ben and Atlee. Thank you, gentlemen, for joining us. The floor is yours.
Thanks so much for having us and having us back. So we are going to talk today about compensatory education and kind of coming back as we start to return to some kind of new normal from these educational disruptions. As Carrie said, there's a lot that's up in the air right now, so we're going to do our best. And we engaged in even more than our normal procrastination in this, because we were hoping that the federal government might release something in advance of this presentation that then we could kind of help frame up and relay to all of you. But there is widely anticipated guidance that has not been released. So here's what we know right now. As Carrie said, I'm Atlee Reilly from Disability Rights Maine. We're the protection and advocacy agency for people with disabilities. And with me is Ben Jones.
Hello, good morning.
And we're just going to kind of pass this back and forth throughout the day. And Carrie, is my audio okay? Because I realized okay, good. The sound is coming out as a computer speaker, and so I was worried it'd be muffled. Our contact information is here. You're welcome to reach out to us. If you're contacting Disability Rights Maine because you want legal assistance, then use the general numbers above and ask for an intake appointment. If you're a service provider or other individual that's just trying to understand the rights of children with disabilities so that you can support families yourself, you can feel free to reach out to Ben or I directly at the other contact information there. So I just want to provide just a brief overview of what we're going to do today. The last time we did this, I know there were questions that came in throughout, and both Ben and I would appreciate that and encourage that. And Carrie and others are going to moderate how those come in either via Facebook or through the chat function here. So we can start and stop to answer questions, but just so you know where we're headed. We're just going to generally give a nod to some existing resources and guidance that we've created, just so that you know where there's other information available. We're going to talk just generally about what do we know about the impacts of COVID-19 on the educational attainment of youth in general and youth with disabilities. We're going to talk about just kind of what the heck just happened and just general kind of framing of the last year with regard to special education rights. And then we're going to talk about really the meat of it is equitable access to learning recovery services, which are different than compensatory education and which are kind of a new concept. And then compensatory education, which is a longstanding concept under the IDEA, And then with that, lots of other terms that are kind of being invented: COVID-19 compensatory education, COVID recovery services, things along those lines. So we'll kind of try and give you an idea of where we are in all those areas. And then just some general tips for advocacy, and to the extent your questions haven't been addressed through the presentation, trying to leave some time at the end for questions and discussion. So I think with that, turn it over to Ben.
Thanks, Atlee. Morning, everybody. Thanks, MPF and Gear, for having us. It's good to see you. We can't see the crowd, but we're imagining smiling faces and coffee cups. So as Atlee said, we're just going to go over really briefly what we've come out with so far. As folks can remember all too well, back in March 2020, a year ago, oh my gosh, we were all swimming in unknowns. And we sought to try to help out folks and try to get a context of where the law was at to do with students with disabilities. So we put out a series of guidances that you can find on our website. And looks like somebody's scrolling over it so you can see. So that's the central space. And I think we'll keep that website up as a static website so you can always check, and there'll be newer things added to that, including this, I would imagine. So we put out initially just some general rights of students guidance back in March, as I said, 2020. And then April as well, really just updating as we went along, as we started hearing from families. We wanted to address specific concerns that we heard. And then we did a presentation with Maine Parent Federation, which was great. I think we reached something like 5,000 people. It was, Carrie will tell, it was great to reach so many folks, but also very, real to see how many folks were struggling and needed help. So, okay, and then this is just another page of some guidance that we put out. Same website. Some more specific responses that we did on guidance to do with things like IRLPs. Folks started to learn about what those were, individualized remote learning plans, and to do with face coverings, making sure that students had access to school and their services. Okay, so on to number 2. So where are we now? So far, there isn't a ton of information about assessing where kids are now, the impacts from the COVID-19 education disruption. There are a few though, and one of the first that we're aware of was Stanford University. They assessed that first chunk of time, the spring of 2020, when kids were out largely on remote or some not at all, and they did a sampling of large school districts and across many different states. And they came up with a few different, I think you want to go one back, Atlee. I think they came up with a few different takeaways just for folks to know this was really the first impressions that researchers saw. Really huge, shocking. It was right off the bat, folks were seeing just for those, let's see, March, April, May, June, 4 months, they were seeing the potential of impacting an entire year, meaning the learning losses of an entire year, really differently affecting different students too. So they were able to parse out disadvantaged students having a more difficult time. So, okay, we can have.
I will just say in the footnote, it's accurately Stanford University. We'll correct that on the slide. It's not university in southern Maine.
Oh yes, there is no Stanford. As far as I know, there's no Stanford University. And again, that's my fault, I believe. So yes, Stanford University. Just 2 more takeaways from that initial study of spring 2020 was the recognition of the researchers that the traditional models of school would likely not meet the needs of students, meaning a teacher in front of a group of students is likely not to address those same needs. So they didn't call for specific flexible or creative ways, but called on educators and stakeholders to think broadly about how to recover that time. And then assessment, yeah, we'll come back to this as well. This is a big missing piece right now. We don't know where kids are at based on data. We've had varying different state established testing that has changed over time. And so getting a baseline is important, and then also seeing where we're at now. So that's going to be a big piece, an important piece for us to learn where we are, is the data. Oh, and yeah, I think this is the one last point on the Stanford's study, which is that communities with the largest estimated loss of learning, they're likely to have the least means to address it. And then importantly, they said, and very relevant to Maine, the insistence on local autonomy to address learning loss is not going to yield equitable responses. So we can all take that to heart. Another study that came out a little bit later, this one came out in December of 2020, and it looked at the fall, so the first quarter really of 2020, the 2020-2021 school year, and compared it to the previous fall. And they saw significant drops in reading and math across grade level. The numbers I think here are only 67% of students were learning at the math rate that they were at 87% the year before. So 20% drop in math level. And on average, students lost 3 months of learning. So again, these are snippets of time that are compared to another comparable time during the school year. And I imagine we're going to see more and more of these. I know that at least one is coming out very, very soon that's going to collapse or combine a bunch of these studies and take a broader view. So keep an eye out for that from UCLA. And then one other takeaway from the McKinsey study was that learning loss was acute in schools that are predominantly serving students of color, where scores were 59% of the historical average versus, 59% of the historical average in math versus 79% in reading. So we have to compare that back to the previous slide, but lower. And yeah, okay, thanks. And just to take away, so what we have heard so far, this was just reported out to Portland Press when they were reaching out to schools to say, hey, where are you seeing kids are at? They heard about high school rates mostly of failure. And the ones that reported in the press were all increasing rates of failure. So dropping rates of achievement. And the ones that were highlighted were Biddeford, Portland, Gorham, and Brunswick, all reporting somewhere between 8 and 10% of drops in high school achievement. So the failure rate was higher than it was the year before. Again, this was a comparison to the previous first quarter. Okay, this was interesting. I just stumbled upon this last week, but a group called Barabo, there's a site, I believe, yeah, down below, that you can go to and look at. You can run your mouse over the states and it shows you kind of how open they are based on scheduling. So that they have a bunch of metadata and they were able to look at how open schools were based on their in-person scheduling. And we have heard for a while that Maine was likely more open than other states, but it was surprising to see that is not the case. It might have felt so in relation to Massachusetts. Massachusetts is the only state that's less open in the Northeast than Maine. Maine being second least open, and then countrywide, Maine is 39th out of 50 states in terms of how open they are. So we're towards the bottom. As folks know from their local districts, it's about a 50-50. Kids are getting typically 2 days in person, 2 days hybrid or remote rather. So that's an interesting thing to look at and something to bring into the discussion of when we're looking at how to recover this time. And I think now I'm going to hand it back over to Atlee.
Thanks, Ben.
Yeah.
So I'm going to collapse what usually takes, an hour into just a few minutes, just so that there's just a kind of common understanding and just refresher on kind of what does the Individuals with Disabilities Education Act do. There's really 4 key, areas when we talk about this. Schools have an affirmative obligation to identify kids who might have a disability and might need special education services, and then to evaluate them to determine if that is so, sometimes called the child find duty. That has not been paused or it has gone away. It's not waived. And to be honest, it's probably more important right now than it's ever been. right? As students have potentially have had existing needs exacerbated by the impacts of the pandemic, and new needs may have arisen. Then schools have to evaluate students in all areas of suspected disability, determine if they need special education, and if so, serve them. How do you serve them? By providing a free and appropriate public education, which we'll talk about briefly, and then in the least restrictive environment. And then you need to comply with procedural safeguards. So, that's kind of it in a nutshell. My guess is most of the people on this call kind of have that general sense, but I didn't want to just breeze past it. When we talk about free and appropriate public education, which we'll do throughout the rest of the presentation, this is just kind of the general framework to be aware of. For a very long time, that term, which is defined loosely in the IDEA, but the substantive, aspects of it have really been defined by courts, and the Supreme Court ruled in 1982 that a free and appropriate public education didn't mean that you had to maximize potential, but instead you had to provide a program based on the student's unique needs and reasonably calculated to provide some educational benefit. And that remained the standard for a very long time until INDRU in 2017. And now there's essentially kind of a potentially two FAPE standards, really, is one way to read it. It typically means for most students, the vast majority of students, what does FAPE mean? It means that you're getting services that are reasonably calculated to permit advancement through the general curriculum. You're moving from grade to grade, you're accessing the same content as your peers, and you're being assessed in the same or similar ways. That is the vast majority of students. Then the court seemed to leave room for students with disabilities who that may not be reasonable. And for those students, a FAPE is reasonably calculated to enable that child to make progress appropriate in light of their circumstances. What exactly does that mean? I'm sure that people will litigate that for a long time. I'm not 100% clear what it means, but the court did provide some helpful information in saying that those goals that we're helping a child make progress towards need to be appropriately ambitious. What exactly does that mean? I'm not exactly sure. And designed to help meet challenging objectives. So there are some markers that the court laid down to where for the vast majority of students, again, the students are going to be judged against their progress in the general education curriculum, and do we have a program in place that's reasonable to support them in doing that? And then for a small number of students for whom that's not reasonable, we're looking at appropriately ambitious standards and challenging objectives and supporting them in reaching those. For all things, and this will be important through the rest of this, and Carrie, I see you're about to ask a question maybe, but this will be important as we go on through the presentation. A free and appropriate public education is an education provided in conformity with the IEP. So while there may be some fuzziness and some room for discussion about what does reasonably calculated mean, what does appropriate in light of circumstances mean, one area where there's not really room for discussion is a FAPE provided in conformity with the IEP? And the answer to that is yes, it has to be provided in conformity with the IEP. The IEP is what is supposed to reflect the team's judgment and decision about what would provide a FAPE. And then once the IEP is in place, it needs to be followed. So Carrie, did you have something or someone have a question?
Not a question per se, but just I wanted to address the appropriately ambitious, because this was recently brought up on a phone call I had with fellow parent training and information centers in our region, and the center in New Hampshire brought up a good point, which I just wanted to emphasize, and your appropriate ambitious brought it back to memory. And as we look to reassess new present levels of performance for our students to address any learning loss from the pandemic, it's important to remember that just because there might be some regression, that it doesn't mean that we're lowering the expectations on the IEPs, and that our goals still remain appropriately ambitious. So there was a concern raised in New Hampshire that as we do this big reassessment of our students with IEPs, that that might mean the lowering of goals, and that's not necessarily what we want to do. We want to make sure that we're addressing the new present level of performance, but that we remain ambitious in our goals for these students as well. And we continue to set the bar high, that we're not going to lower the bar. And your I feel like the term appropriately ambitious was completely appropriate, and I wanted to just sort of reiterate that for parents to let them know that you should still have high expectations of your students and encourage your goals and your IEPs to be high, even though there may have been some regression.
Yeah, no, that's an important point, and we'll kind of come back to that multiple times in multiple ways, but it's extremely important. I mean, people need to remember, as we're talking about where kids are today, is where did we expect them to be today a year ago, or 13 months ago, if that makes it easier. And that, that's part of our baseline here, and so we can't just and we'll, again, we'll loop back to this, but I think that's a really good point. Thank you. So the least restrictive environment, again, just going through complicated concepts extremely briefly, but what the LRE means is to the maximum extent appropriate. Children with disabilities are educated with children who are without disabilities. And schools can only remove students with disabilities from the general education setting if education in regular classes with the use of supplementary aids and services can't be achieved satisfactorily. So nothing changed about the LRE either in the context of the pandemic. And then again, the procedural safeguards, because I think this is going to be really important whenever people start thinking about what did just happen and where do I go from here, to really focus on where maybe the procedures got thrown out the window as a way to frame up any concerns that you may have. So you as a parent have an opportunity to examine educational records, participate in all meetings related to identification, evaluation, and placement. And importantly, you have a right to prior written notice whenever the district proposes a significant change in the IEP or refuses to initiate a change you requested. And that notice needs to include, among many other things, but a description of what the school wants to do or what the school is refusing to do, explaining why, give you notice of your procedural safeguards, describe other options that were considered, and describe factors relevant to the decision. And that'll become important as we talk about addressing potential compensatory education. So IDEA hasn't changed.
Will you be, Atlee, will you be addressing extended school year later in the presentation, or would it be appropriate to ask?
We don't have, you can go ahead and ask it now. We don't have a specific point in the presentation.
There's just a question about, and I think it's still going to be individualized IEP team decisions, but may all students with disabilities be eligible for extended school year services due to the regression that has occurred during the pandemic?
So the ESY calculus hasn't changed and shouldn't change really as a result of COVID. I think really maybe what the person's getting at is, wouldn't the summer be a good time to provide compensatory services? And so I think when we get to that, I mean, we can tease out where does ESY fit in this. And ESY, kids that needed extended school year last summer are likely to need it again, and it shouldn't be, that would be kind of an easy way to say, well, we're doing comp ed because we're giving everybody ESY, but really it should be an individualized determination. And it might very well be that some students need ESY and they also need compensatory education, and they also need access to the COVID recovery services applicable to all kids. And so I think maybe if we loop back to that a little bit as we talk about all those various things. But basically, if you take one thing away from this, it's just that all these things should be individualized, just like they always were before the pandemic. And it's kind of the elephant in the room with regard to ESY is that's one of the least individualized things that we do in schools. And it doesn't make it okay, but the practice in Maine and elsewhere seems to be that schools kind of backwards engineer their ESY programs, and they decide the programs they're going to offer, and then they offer those programs to a certain number of kids. Now, that's not how it happens all the time, but I think this would be a good year to ensure that happens less than it has been, and make sure that these are individualized conversations and determinations. So IDEA hasn't changed. The USDOE has made that clear. There's a Q&A document that there's a link to in the slides that they put out in September 2020, that these are just some of the big takeaways. You still have a right to FAPE in the LRE. Parents need to be part of the IEP process. You have to get prior notice before changes, even if agreements are made outside of IEP meetings, and you need to consider alternative methods of delivery. That's appropriate, and we'll talk about that. Just because the method of delivery was changed doesn't mean that the IEP was violated, but when services are significantly reduced, or when students aren't able to benefit from changes in delivery of services, or when parents are not involved in decisions about that, then that's where things start to get more complicated. And then timelines haven't been waived or extended. So what we're going to really spend the rest of the time talking about in various ways is what are common ways that the IDEA was violated over the past year, and then what can be done about it. Generally, IEPs were not implemented as written. That's probably the top one. IEPs were changed outside of IEP meetings and without parental consent or without prior notice, and we'll talk about each of these in more detail. They were changed at IEP meetings, but those changes weren't based on the individual needs of students. Parents might have heard, like, this is how we're doing it. This is the way it is for everybody. That's not an option. This is not an option. We can't do it that way. This is the cohort, all variations of things that were not allowing teams to have individualized discussions. And some of these, may very well have had very valid, public health reasons, right? And so the schools and the staff at these IEP meetings were in a tough situation, but it's still the result of it. And one of the things we'll kind of talk about here is, we have to get, it's not about bad actors or not bad actors. It's really about, did kids receive a FAPE? And if, as a result of these changes, a child didn't receive a free and appropriate public education, and they were already potentially behind and struggling to keep up with the general education curriculum, then we have to fix that. We can't just kind of act like it didn't happen. And so, we'll talk about that. But a lot of IEP teams had their hands tied by school administration, who felt like maybe their hands were tied by state regulations, and often were complying with likely necessary health and safety regulations. So all this is complicated. But what's not complicated is, if kids didn't receive a free and appropriate public education, we have to figure out how to make up for that. But the reasons for it are complicated. And the emotions around it are going to be complicated, I think, going forward. So the needs of students unable to receive a FAPE through remote instruction weren't appropriately addressed. Some districts did an amazing job in this regard, and other districts really just stuck to the line that we just can't do it. Can't do it, won't do it. We'll make it up later. Well, now is later, and so we're going to have to figure out how to make it up. And then evaluations were delayed, and or new or emerging needs weren't properly addressed. I mean, a lot of schools are scrambling to meet their evaluation obligations. And I would imagine, there's going to be a real push. It's always this time of year anyway, to kind of hold people off until a certain time, to when we know that you get your 45 school days doesn't run until next fall. So we're kind of in that area right now, where people are probably already looking not to do any more evaluations than they've already kind of signed up, to hopefully clear the backlog. But my guess is that we're going to really need to be looking at doing evaluations year round here for a little while to catch back up. So we'll talk about each of these in a little bit of detail. Carrie, are there any questions just generally before? Okay. So IEP is not implemented as written. That's probably the biggest one. It's probably the thing that the most families on this call have wrestled with, and it's what most of the families that have called our office have had as an issue. Again, as I mentioned, a free and appropriate public education is defined as an education provided in conformity with the IEP. So if the IEP wasn't implemented as written, that's a problem. The failure to implement a material or significant portion of an existing IEP is a denial of a free and appropriate public education. And I just wanted to note that, and I mentioned this earlier, but it's worth repeating, there are kind of emerging trends in the decisions. Things are still all over the map. And there's not a lot of court decisions yet on these issues. What kind of we relied on in putting this together are other states' complaint investigation decisions and other state hearing decisions, and the relatively few that have happened in Maine. But just generally speaking, there is a distinction that's being made between changes in the method of delivery and changes in the amount of service. So if a school continued to provide all the services on the IEP, but they did it through remote means, and the student was able to continue accessing those services, in general, nobody's finding a real issue with that. But if services went from 6 hours a day to 30 minutes a day, in general, states and hearing officers are finding real issue with that. So that's kind of the general trend. I'm not going to read this. This was part of some of our earlier guidance, but just wanted to throw it in there. This is really focused on IDEA, but just a nod to Section 504 is in play here as well. And there's a FAPE requirement under Section 504. And what the US DOE said in several different ways with regard to 504 and the ADA are like, look, schools, you're gonna run into problems when you dispense with the individual decision making, right? And so things still under 504 need to be individualized. Things under IDEA need to be individualized. So when there are district, state and district-wide decisions that basically limit or reduce services without regard to the individual needs of students, then that's legally problematic. So moving on from that one, well, no, actually, this is from earlier guidance as well, and I just wanted to hit this. A lot of families probably heard that, we're just going to meet the intent of the IEP. Is that all that schools had to do? And the answer is no. Again, a FAPE is delivered in conformity with the IEP. This was early language, and there was, both out of the federal government and from the state, there was some potentially confusing language early on, and some of this language just persisted. Sometimes we all hear what we want to hear, and we sometimes remember what we want to remember. And this isn't the standard. It wasn't, the FAPE standard wasn't altered, so just trying likely isn't going to be seen as good enough. Actual implementation of the IEP will be required. So my child's IEP was changed without an IEP meeting and without my consent. This is probably the second biggest issue that we're seeing, and usually this is coming up in the context of IRLPs. And when you ask families about how that happened, a lot of times families describe just being notified that there was going to be an individualized remote learning plan created, and that would be in place during the time the school was in hybrid, or if the district went to red, or some of that got very confusing because the state had red, yellow, green, but then schools would kind of implement their own system if they had a regional or localized outbreak. And so, but at any rate, there was this concept of an individual remote learning plan, which in theory, and we have some guidance on that, we didn't disagree with, but in how it's been implemented, the primary problem with that is twofold, and they're really related to each other. One is that a lot of times those weren't really based on the individual needs of the student. They were just based on what the school felt they had the capacity to provide under the existing guidelines. And then two is parents weren't told that they had the right to have consent to that. They were just notified of these changes and given prior written notice. And so the idea is when changes, and what IDEA requires is when changes are made outside the IEP meeting, they have to be based on consent. And it just seemed to be this pervasive idea that all parents needed to be was informed or put on notice of it. And that's true if you go to an IEP meeting under the law right now as it exists. You go to an IEP meeting and there's a disagreement, and the school says, well, this is what we're going to do. We're going to implement this individual remote learning plan, and they can give you notice of that, and after 7 days, then they can implement it. But the vast majority of those, at least when we talk to families about it, happened outside the IEP meeting process, and those have to be based on parental consent, and that didn't seem to be communicated to parents, or potentially even understood by all schools. So there's also kind of a corollary issue to that. Is you change an IEP at an IEP meeting, but they weren't based on a child's individual needs. Again, I stands for individualized. as I mentioned earlier, many IEP teams were really limited in what they could or couldn't discuss as far as like level of service. Could you go on a Tuesday? Could you go on a Thursday? Which cohort were you in? What happens if the teacher that you usually go to has to span cohorts, and what does that mean for your services? There were all sorts of things that were kind of determined before these meetings were held. And for some students that wouldn't have caused, didn't cause any harm. And for other students, it may have caused significant harm. And just the lack of having kind of an ability to have this individualized process may have led to additional violations. So this one, kind of related to the other, I'd say, we got a lot of calls about this, especially early on in this school year. A lot of people, March, April, May last year, everybody was just kind of hanging on. And then at the beginning of this school year, when remote learning still wasn't working for students, families were really seeking other options. And so sometimes they would go to school districts and they would seek other options, and they would be told there really aren't any other options. Sometimes there wouldn't even be an IEP meeting held. Other times schools would, as I mentioned, really try and problem solve this with families and say, we understand, here's what we're going to try and do. And I'd say, almost all families that schools showed that they were willing to be flexible and work with them ended up being okay with whatever sort of compromise was reached in that process. But the families that just kind of hit a stone wall on that typically were not okay with it. And I think they had a legal, basis for their concern. This is just from
Atlee,
yeah, go ahead. Sorry.
Can I ask a question about LRE?
Yeah.
So obviously the cohorts made it confusing with LRE, and some families were forced to choose between being put into a special education cohort and not necessarily having access to the typically developing classroom, or being put in a typically developing classroom, but receiving some of their services, which would have generally happened in a resource room as pull-out services in the back of a classroom, where it might have been distracting. So they were getting pulled out pre-pandemic, and then they got switched to the back of a classroom during, due to those spacing and requirements and space availability. And it was under, having access to your LRE, but it was too distracting for them to get their services. So what would be required of the district moving forward to make sure that those services the fidelity of those services aren't compromised by a cohort decision and spacing? For example, should there be another space provided so that child could receive that pull-out services if the fidelity of them in the back of the classroom are being compromised? It's kind of, does that make sense?
Yeah, so just quick, I don't think the heart of the question is necessarily an LRE issue, but just to speak to LRE briefly, we expected a lot more calls about this particular issue than we received. And I think what happened is probably families were so happy to get whatever services that they could, that they were willing to kind of trade the access to more in-person service to a less restrictive environment. And so, we don't take action on things when people aren't, raising those concerns. And I just heard less reports about that than I was concerned about. Than we were anticipating. We're concerned about it. And one concern would be that those kind of temporary agreements become permanent. And what we know from the research is that once it doesn't get easier to be given access to the general education setting, and removals beget removals, right? And so as to LRE, to the extent that families and students were not given access to the LRE outlined in their IEP, that was inappropriate. But again, it was done a lot of times with the blessing of families, is what I'm gathering. And so we have to figure out, how do we come back from that? And the students may need some additional support over and above what they were provided during those push-in services to continue to access the general education setting. As far as like being in the back of the room and it being distracting, that again is, that's just an issue about like this service delivery model is not working for me. And to have that question, I don't think it's necessarily an LRE issue. It is.
I don't think it's an LRE issue. I think the argument was made, or could have been, I think the question comes from the school district would make the argument, well, if you want access to LRE, that's where the services have to happen. When in actuality, as a parent, you can ask for, say it's reading instruction and your child is, it's a specific evidence-based program that your child is getting, and they're getting it in the back of the classroom so they can have access to LRE, but they're highly distracted and the program isn't working as well as if it would have been given in a one-on-one situation in another room, and the school, they don't have the space to do so.
Oh, I'm sorry. I don't believe that what you're describing is inclusion. At all.
Right.
Like if a student's in the back of the classroom working on something different than everyone else is working on, that to me is just, it doesn't make much sense. If instead, like what they're getting is push in special education supports in order to support them in working on what everyone else is working on in that classroom, then that's kind of the LRE issue. So it just seems like, This is more because of the cohorts that were created and to keep people safe, that you saw instruction that may have been pull out previously being given in the back of the classroom because there wasn't enough space to provide it as pull out. And the child had made the decision to be in the cohort with their typically developing students and not the special education cohort. And it was to have access to their least restrictive environment, which was typically developing kids. So I think, that's just a discussion with the IEP team about this isn't working, and the student and the family shouldn't have ever been put in that position. And schools could have, potentially designed the cohorts in a way that would actually have meaningfully advanced inclusion. You could have seen it going a different way, and some did. But sorry to be a little bit dense at the beginning on what you were asking.
Okay. So in other words, parents should, so Angie, in response to your question, parents should advocate if that's not working for another space to receive that instruction so that it works and the fidelity of that instruction isn't compromised for that child. And that's where an IEP team comes together and has that discussion and individualizes the child's instruction. I have another question about attendance and truancy and how it fits in. If a student needs a structured routine, but due to remote learning has been home and struggles to go back to school, how does attendance and truancy fit into this cog?
So, school, there's a lot of really good, there are a lot of good decisions and support for the idea that school refusal behaviors or other things that are getting in the way of students attending school are significant issues for the IEP team to resolve. And so the resolution is going to look different for everybody, but gone are the days when schools should be taking the approach that, well, we've got a great program for that student if you can just get him here to school. And so if a student's not coming to school, and it is, I anticipate that sort of thing may increase. Students have become potentially very used to the routines that they're having at home. Disrupting those is going to potentially be difficult for some students. And so I think it's going to look different for every kiddo, but the IEP team needs to come together and address it. And if there's a concern that because of past difficulties, that it's going to be worse now in the future when a student, say, returns from an extended period on remote, then addressing it proactively would also be appropriate, I think, for an IEP team.
And then finally, and I can't believe I'm dealing with a mask question in March, but I have a parent here who says her son has Down syndrome and autism, 20, developmentally age 3, attends a specialized school outside of the district, has not been able to attend as he's not been able to keep a mask on and is receiving half-hour a day of circle time and 2.5 hours sessions of speech. At this point, he's missing PT and OT. So it sounds to me as if they're denying access because he can't keep his mask on, and not getting his full IP.
Yeah, I would just refer them to like some extensive guidance we have on that. It's pretty late in the year to be getting such minimal service. And so, they could certainly reach out for an intake appointment. But since we're going to be struggling to get through this, and since I just don't want to go into the whole mask world right now, but certainly our guidance hopefully will be helpful, and questioner can feel free to reach out for an intake appointment. So last piece is evaluations, and I think I covered that kind of in the intro, but evaluations and should be proceeding. And even for students that they don't maybe need a full reeval, or it's not due, or conditions don't warrant a reevaluation, there really is very likely a need for a lot of curriculum-based assessment and other measures to figure out kind of where we are. And I think some schools are doing that, and other schools, struggled even before the pandemic of knowing kind of where we were on a regular basis, especially for students with disabilities. So those types of things are of heightened importance now. So I think that I get to stop talking now, and it's to you, Ben.
Okay, take a break. Thanks, Atlee. Yeah, and I can see Carrie as well. There's more questions coming in. Certainly give folks our contact information as well, the intake, because I think some individual issues are coming up, but we will hit a lot of the issues being proposed. So, okay, well, let's talk a little bit about the impacts generally from COVID. Really, this is in the context of thinking, well, how do we get to where we should have been, but for any failures that have happened in the past year. And like Atlee highlighted at the beginning, there's going to be whole school approaches, and those we're highly encouraged, that those are going to help all kids. And part of it's going to be making sure that kids with disabilities have access to those, and then versus compensatory education being individualized and focused on that particular kiddo's needs. So this is just a few points along those lines. Making sure that students have access, conducting additional evaluations to determine impacts. Make sure you identify new needs that have risen. So this would come back to the idea of child find. So if new issues have arisen because of the impacts from the last year, I can think of things like trauma or anxiety emerging. And then address compensatory education through the IEP team process. So this resource is a great one that came out recently, about 2 weeks ago, and covers a lot of this idea. So making sure that students with disabilities are at the table, at the forefront, given access, and a part of all of the general recovery. And a few points along that: ensure all students have equal access to learning recovery. And also, just to highlight before, when we talked about ESY is individualized, even though it often doesn't, often the programs look cookie cutter. They're intended to be individualized, and they don't need to be during the summer. So we brought that up before, but those can be on the weekends after school, vacations, times outside of the regular school day. So as far as IEP teams find that useful, they should think creatively about ESY. Ensure all students are educated in LRE. So they highlight a lot of the general IDEA concepts within this inclusive learning recovery document that I'm referencing here, but they become especially important when we're talking about new programming that kids might need access to. Incorporate inclusive progress monitoring practices within learning recovery program. So there was a bit of discussion just now about inclusion, whether it's meaningful or not. This is an opportunity for folks to refocus on what it really means to be included. So compensatory education generally under IDEA, it's not written in there. If you look for compensatory education as a term under IDEA law, you will not find it. It's been created by case law and by judicial decisions. And this is one particular case that does speak to it from right here in our own First Circuit. And that's Phil versus Mass. And imposing liability for for compensatory education services on the defendants, quote, merely requires them to belatedly pay expenses that they should have paid all along. So this was a case where a student was aged out of services by the time that they were addressing what needs for compensatory education was being had. And there was an argument from the district that, well, the kiddo he's beyond the age of of eligibility, and so therefore it affects his compensatory education. And they said, no, he certainly has access to it, and we want to look at what is needed to get him to the place he should have been. So compensatory education, it's not generally available for purely procedural violations, unless there's also a denial of FAPE. So when you think procedural violations, it might be a delay in evaluation. That might be a procedural violation. But if that was an extended delay and it was something the team needed in order to provide an appropriate program, that might weigh towards more of a material effect and have a denial of FAPE. Procedural violations that significantly impact the ability of the parent to participate can be a denial of FAPE. And material failures to implement the IEP violate the right to FAPE without need to demonstrate educational harm. So when it's to the degree of a material failure, you don't have to show that the student has regressed to a certain degree. It is in and of itself a failure to provide FAPE. Okay, and this is, just to talk about the different ways in which compensatory education can be delivered and ways that it's been contemplated in case law so far. There's really two approaches, quantitative and qualitative, and neither is right or wrong. It's just going to be a guidance for the IEP team to speak about and for legal arguments to be made for later. Some folks approach it as just a quantitative approach, and that's really just one-to-one. You missed 20 hours of speech, so you're due 20 hours of speech. What this misses out on is that context of, well, we're 12 months later since the COVID disruption, and where should the student be now? And is those extra 20 hours of speech, is that going to get them up to where they should have been? Or is that going to be just, making up for that distinct period? So qualitative approach seems much more in line with the goal of getting a student to where they should have been. And this is the case under REID, R-E-I-D. But the goal is to determine and provide the services necessary to put the student in the same position that he or she would have been, but for the school's violations of IDEA. So that's the way we approach it. So delineating between compensatory education and COVID impact, there's, like Atlee said, there's all these different terms that have come up nationally and chatted about within the state. These are new ideas. They're not necessarily dictated in any way, but compensatory education is very clear, like we just talked about, based on the case law, and that's individualized. You meet, you talk about the kiddo, where they are now, where they were before. Do we need more information to know where they are now? Let's do it. Let's get into this. Versus the COVID impact, we see emerging as more of the general impact, the general services that might be to address learning loss for many students. And DOE put out a document about this early on, and they cited that COVID-19 impact recovery services are not compensatory education, so defining them differently. And they're really meant to remediate lost skills due to remote instruction. And they may be intended to improve outcomes for students who are not able to meaningfully engage in remote instruction or had limited progress. So an acknowledgement that remote really might not have worked for some students, and something needs to be made up in that regard. State and federal guidance on, Atlee has something. Yes.
Oh, yeah. No, you can keep going if you want.
Oh yeah, no. Did you see a question or anything that was relevant?
No.
Okay. Am I slided out? Is that what's happening?
Yeah, but if you want to keep going, I don't have to.
No, go for it. I lost track of the slide numbers. I'm sorry. Go ahead.
No. So one thing on just that last slide is that just to underscore that there really is no such thing as COVID Comp Ed. It's something that really, and I think I mentioned this earlier, is schools often, when they, in the past, when there's been compensatory education claims against schools, it's been framed in ways of like, that the school did something wrong. And so there was a lot of, there are a lot of folks, and I think for good reasons, that were concerned about using that type of language to talk about what has to happen to address the inability in some cases to implement IEPs in March, April, May of last year. And so that's when people started to really push for something else. So they settled on this COVID compensatory education or COVID impact recovery services or some various things. But these are just things people are making up so that we're more careful and less likely to kind of hurt other people's feelings when we just talk about this. But really, it's just reframing it as like, if kids were denied a free and appropriate public education, maybe schools had to deny them that. I mean, the school was completely closed in March, April, and May, and they couldn't be in person. So it's not really a blame situation. It's just a here we are now. Where do we go from here? To that point, it's not. We're not going to go through what other states have said about this, but just know that a lot of other states have spoken, about what should be happening. So New Hampshire at the end of last year said, you've got to meet, every IEP team needs to meet, and here's what they need to discuss at these IEP meetings. Massachusetts, similarly has a lot of clear guidance. At this point, my guess is states that haven't issued guidance are kind of going to wait for the feds to issue theirs, because it's, again, widely anticipated that there will be some federal guidance in these areas. But just to kind of underscore that Comp Ed was something that's judicially created. It's only mentioned in the IDEA under the state complaint procedures just one time. And then this COVID Comp Ed is just something that we're kind of all collectively making up right now to talk about what we need to do when schools were kind of closed and schools couldn't implement IEPs. So I think this is a really helpful document. There's a link to it as well. The Council of Parent Attorneys and Advocates issued a statement on compensatory ed in the summer of 2020. And I think it's important to really, frame things this way, that you don't need to show that districts were at fault or bad actors for students to be entitled to Comp Ed. Some schools, and we saw this in Maine, some schools really did have a really robust response to the COVID-19 closures. They were just unable to meet the needs of certain students, right? They couldn't really meet those students' needs while they were forced to be remote. Other schools hardly tried, and we saw this as well. I mean, I've seen, students who for months and months got packets who really needed, even if it was remote, some intensive one-on-one, human-to-human interaction. And so, but a lot of schools did what they needed to do. It doesn't matter. A student who didn't receive a FAPE is entitled to compensatory education. So I think just talking about it kind of matter-of-factly could potentially helpful. And there's a lot of other stuff in this statement that could be helpful to you as you're advocating. This is in some previous guidance, but just thought it was worth revisiting here. What do you do? What can I do? My child's fallen way behind, hasn't made the progress that we hope to make. At a minimum, we need to figure out where we are. IEP team needs to meet, review results of assessments, and begin to understand these impacts. I hope teams have started to do that. I know they have in some districts. And then if we need remediation, the IEP team needs to develop a plan to address any learning gaps that emerged and any lack of progress toward goals. It's not just about regression. And there have been some arguments made in the state about that we really need to be concerned with regression. Did kids regress? Well, we're talking about a year here. And we're talking about students who we had annual goals for. And we're talking about school districts that have graduated, soon to be another 2 years of students. We have to assume that regression isn't the benchmark, that we had an expectation for students without disabilities that they would continue moving through the general education curriculum and advancing from grade to grade. And so to try and measure what's happened with regard to the impacts of COVID and use regression as the yardstick seems to me to fall very, very, very short even at the start. So just making sure the lack of progress toward anticipated goals is considered as well, because we did have expectations in February of 2020 of where kids would be in February 2021. And those expectations were required under the IDEA to be reasonable, to be appropriately ambitious. And so we shouldn't just toss those out whenever we're deciding what the impacts of these disruptions were on students.
Atlee,
Yes.
I got a question about asking for a COVID compensatory education instead of possibly retaining the student. Is it appropriate for a parent to request that?
Yes. I mean, retention is, I hope that our response to this is not just like the large wholesale retention of lots of children. And if that happens, it's almost certain that the results are going to be, the retention is going to be inequitably distributed. My understanding of the research related to retention shows little to no positive benefits of that after a very early age. So I'm not completely up to date on it, but that is my sense, is that that after a certain age, sometime in elementary school, late elementary school, that the harms of that act will outweigh the benefits for most children in most circumstances.
Yeah,
So
you're correct. That data still exists about
yeah.
Retention. I think it's also
So,
important to remember that retention is not an IEP team decision. And that's where a lot of parents may get confused or don't know. Retention is strictly a building administrator's decision. So it's typically the building principal that has that final decision. It's not an IEP team decision. So that needs to be made clear to parents. And when you're talking retention, it's not just about academic gain, it's about the social and emotional harm. So for kids, seeing their peers move on and them stay behind can be really, really damaging. So those are considerations that need to be made when considering retention. And then Atlee wants to take the compensatory ed part of that. That would be great.
Yeah, I just want to say though, with retention, I mean, it is very much the province of the IEP team to have a robust discussion about developing a plan that would support the child in accessing the general education curriculum going forward, which would have the result of avoiding retention. So like I think it's really important that the IEP team has a voice in any sort of conversation like that.
Yeah.
So, but as far as compensatory education, yes, I mean, you know, it's all part of the plan. Like, how do you come back from this is going to depend. What does the individual student need? Do they just need, I bet a lot of schools are going to be offering summer school to a very wide range of students over the summer. Do they just need access to that summer school program with some supportive aids and services to ensure they can access the general credit recovery programming that like the school is offering to all students? If the answer to that is yes, then that's all, you know, that maybe we need to do. Or do they need really intensive one-on-one support to address specific skill deficits that emerged? Or do they need both? Or did they, you know, fail to get any of their related services for 6 months? And so we need to take a more quantitative approach to that and just assume that if you didn't get speech for 6 months, you were harmed by that, and we should give you some more speech without having to like really get into the weeds about what particular harms do we have and identifying that. So I think it's just going to be a mix of things for all students, but the starting point should be, how do we keep this student moving forward with their peers? And so, I mean, if schools are going to like wholesale retain everybody, I mean, maybe that's a different conversation. I don't know if that's retention. It's just kind of like writing off a year of school, but I don't think that's what's happening. And it would be concerning if what comes out of this is that the students impacted the most from this are then further penalized and kind of pushed behind their peers by being retained because we didn't do what we needed to help them keep their heads above water. And so now is the time to have that conversation and like, what do we do between now and September to address it in another way? So does that help?
Yeah, and then just sort of follow up on that. What about CDS kids who we know that services were closed a year ago and where the COVID closures basically added up so much unmet service time that there's no way it could be made up through compensatory education, and the child is aging out and headed into kindergarten next year?
Well, I'm going to let Ben, we have a slide on a systemic CDS complaint toward the end of the presentation. So
okay,
if we can defer that and let Ben talk a little bit about that.
Awesome. That sounds great.
Okay.
And then just live assessments. We're talking a lot about assessments when it comes to compensatory education. What happens if a child needs to face-to-face, but there's no in-person school in the district yet?
Are there still districts where there's no in-person school? None at all?
Assuming she says my child will need face-to-face interaction that isn't available in my school district yet.
Yeah.
I was looking at that question as well, Carrie. I think perhaps they mean to do with assessments, meaning maybe the school is saying that, or the family saying that to access the assessment itself needs to be face-to-face.
Face-to-face assessments aren't available. That's what she clarified.
Okay, well, there are evaluators that are doing face-to-face assessments in the state. And so some students could be adequately assessed through remote, potentially remote or, other means. And others can't. And so for the students who can't, we have to find somebody who is doing a remote assessment, a face-to-face assessment. So, there are a lot of service providers delivering services in person. And so just because the person that the district's contracting with may not be doing that doesn't mean that there aren't people that are. But it also means, I do think when parents can be flexible, they should be. And if your child can if people really feel like they could be evaluated appropriately, and through alternative means, by all means, don't fight that just because. But there are certain students who really, we won't get the information that we need. And so we need to find an evaluator who's willing to do that, or else the team's just going to, not going to have the information they need to develop another IEP. So moving on really quickly here, let's see. Already covered that. So USDOE, again, there hasn't been any real clear guidance, but they made clear from the beginning that schools are going to need to make an individualized determination whether and to what extent compensatory services may be needed. And my guess is whatever guidance does come out isn't going to be like earth-shattering or really change the framework that we're presenting here. It is, if IEPs weren't implemented, if educational disruptions impacted a youth, we need to come together as a team and decide individually what the impacts were, and individually how they're best addressed. I don't know what it's going to be. It's probably going to be a lot more pages than that. But at the end of the day, it's going to say that this is a very real responsibility of IEP teams and of states to ensure that IEP teams are having these conversations, and that they have to be individualized. And there's not going to be a cookie cutter approach. And I'm certain what the USDOE, and I'm certain what the State Department of Ed is going to say is that it's really, really important that students with disabilities and English language learners and anybody else has access to the stuff you're going to do whole school, and so to the extent that those that students with disabilities or others might need accommodations or supports to access those whole school approaches, that should be our starting point. But with the IEP team, that's not the end point, right? So, and again, as Ben said, the goal of Comp Ed is to really put the student in the place they would have been had they received an appropriate education over the past year. Just highlight really quickly, I think we've said a lot of these things, so I'm going to move pretty quickly so we have some kind of at least 15 minutes at the end. But some students are going to need a lot of services. And again, some students are just going to need access to the generally applicable recovery services made available to all students in a district. Got to be individualized. And let's see, I think a couple more things before I turn it back over to Ben. Here's some early trends, and these things may change, but parents appear to be prevailing pretty frequently on claims where it's a failure to implement the IEP, when there are material reductions in services that weren't determined through the IEP process. Okay, so if that happened to you and you file a complaint and it follows kind of the path that these things have been, seem to have been going, parents are typically getting compensatory education when those things have happened. There is a clear distinction being made, and I think it's worth repeating, between changing the nature of delivery of services and reducing the services. So as I read the decisions as they keep coming out, that's a clear distinction being made. And schools are, especially for that March, April, May time, if they delivered all those services through remote means, and if unless there's really clear evidence that the student wasn't able to access it, then that's not seen as a material failure to implement the IEP. But if they cut the services by 75%, that is. It's, I guess, not really surprising when you think about it, but that's how it's shaking out. There's still a lot of uncertainty, and future claims may be significantly shaped by future guidance from USDOE, but I don't expect these two things above to really change all that much. There's been fewer decisions to date addressing substantive FAPE claims other than a failure to implement, and those results seem to be more mixed. But those that are framed to highlight that the process wasn't individualized appear to be better received on balance. So, you know, to the extent you were told this is how we have to do it for everybody, it doesn't matter what's happening to Johnny in this, we can't talk about that. Those are things that if those were said, you know, you would want to include them in a complaint. Again, after you've tried with the school to come to some sort of agreement through the IEP process on Comp Ed. I don't think families should just be rushing into dispute resolution on all these sorts of things. But I think Ben will talk about some of the more general tips for you to in that process. And then just generally, courts were pretty disinclined to become involved on an emergency basis to force schools to implement IEPs as written during the pandemic. So when people sought like relief on class relief on behalf of a lot of students because of pandemic related changes to IEPs, typically those have been unsuccessful. But those are kind of the trends that we were able to pull out. And I'm gonna turn it over to Ben.
Thanks, Atlee. And did you see my chat, Carrie? I think there's been a few questions that we can tackle at the end. Okay.
Yep.
So yeah, so this was in relation to what Atlee's speaking about, what we're starting to see for decisions. We've started to see some right here in Maine. And this was to highlight one particular complaint decision. And if folks don't know, these decisions are all publicly available once posted by DOE. And we included the link, but you can always just Google MDOE decisions, complaints, something like that. This was a situation where a young student, so somebody who was served by CDS, which is legally called an IEU, an intermediate educational unit, and that student had a unilateral change made upon them in their programming. So March 2020 hits, COVID, and the programming was changed really overnight for the student from 15 hours of specially designed instruction down to 30 minutes of a circle, a virtual group circle on Zoom. And was that appropriate? Was that an okay thing to do without involving the team? And the DOE said, no, it wasn't on many different levels. Not involving the team was a primary issue. It was a fundamental change in the programming. It wasn't just simply a different way to deliver the 15 hours. It was a completely different program. And as you can see, you know, much less, 30 times less. And that program itself, just standing on its own, the 30 minutes per day of Zoom group chat, was not specially designed to meet the students' needs and didn't provide them a FAPE. And also this decision looked into and made factual findings about the students' ability to access remote learning. So this will come up for a lot of families where they're trying to assess, well, I got some remote, I got some in person. I feel like the remote wasn't effective, but I'm not so sure, and trying to look through that. This is a case where they looked at how the student was able to access that and said, no, they weren't. And some of those factors were that they were distracted. They were only able to sit in front of the Zoom for a few minutes, and the family had to be right there with them to have any access at all. So different pieces that made it clear that they just didn't have access to remote learning generally. And I already said not involving the IEP team was a violation as well. So this one provides a bit of a roadmap for folks that have a similar situation, but as we all know, it's going to be very individualized. It's going to be always different for different kiddos. Perhaps it's not so clear that they couldn't access remote, and so therefore not considered a violation of FAPE for that piece. But oh yeah, this is that's that website I mentioned where the decisions can be found. And so if things don't work out at the IEP team, we encourage everybody, even when we get a client coming in and there's a a live issue. If things aren't clear enough that have been, requested by the parents and discussed by the team, and it's clear where everybody's at, oftentimes we'll just say, well, have an IEP meeting, see where folks are at, make clear requests, and then go from there. And so folks can do that without ever needing to reach out to MPF or us, really just call a meeting and try to address these different areas, the current programming as well as compensatory education piece. There's no reason the IEP team can't cover all of that right there in the collaborative process. But if that doesn't work out, there's other levels to access. So DOE provides for these in the sense that mediation is administered by DOE. They provide a free mediator. It has to be voluntary on both sides, like any mediation. And perhaps then can be resolved that way. And the nice thing in Maine is that stay put applies to mediation. It doesn't other places. And that's really helpful. So the program just freezes where it is. The team discusses, do we need to make a change? And then it goes from there. And then going up in levels, you've got complaint processes. So when I referenced that complaint on the prior page, that was the result of a complaint investigation. And just briefly, that process is sending into the DOE saying there's an issue to do with special education. Here's the facts. And they take 60 days and assign an independent investigator to look into it. They interview the family, they interview the school, they review documents, and they come out ultimately with a report. And if there needs to be changes, a corrective action plan. And then the most intensive, dispute resolution is due process. Atlee, I skipped ahead. We're back. Is the due process hearing process. So that's most like a lawsuit, in the classic sense. It can be done pro se, by parents, but not often recommended to do it on your own. It's just so involved. You really would benefit from having legal assistance in doing a due process hearing. Okay, next slide, Atlee. So I'm going to cover, we're going to go through the end here. So I'm just going to cover a bit about how you can approach these things. We've given you a bunch of information, a bunch of resources, and you'll have this recording as well as we'll send out the PowerPoint, I think, next week. And those are good just to have as background, but just in terms of tips, how to approach this, I already mentioned just call an IEP meeting. That's really always the great first step. And just start bringing up this conversation about compensatory education, or if you've already started to hear about the general education, generally available COVID recovery services, just how is my kiddo going to get access to that? I know this summer there's going to be 10 hours a week available to everybody. And so I want to make sure they've got all the services that they need to be able to access it. Consider inviting providers outside of school. That's always a good general tip. I'm not sure what we meant when we put that in there, but just generally involve folks that are knowledgeable about the child and need to contribute to the team. Maybe it's a certain assessment that might need to be done by an outside provider, or really, I always encourage families just to involve anybody that's involved in serving the kiddo outside of school too. So oftentimes kids might be getting waiver services from Maine Care. Those folks can provide a bigger context, especially too, I'll stop on this for a second. So especially too, because there's been folks that have been providing services for kids throughout the pandemic in their home that have a different perspective than the school, and they were focused on different things. So they might have a treatment plan they're working on, and they might be working on, living skills with the student, and they might have been nearby when this kiddo was trying to access remote learning. So that sounds like a valuable person to me to bring to an IEP team meeting to talk about where a kiddo is at now. Request information prior to the meeting regarding assessments and services provided since the beginning of the disruption. So hopefully schools have been keeping track. I know I've seen progress reports where it is said, well, there's a COVID-19 disruption going on, and so therefore we don't have any data. That would be unfortunate if that's widespread, and hopefully schools have done a good job of keeping track of kids, but certainly ask for it, anything that they have, whether it's samples of work or progress notes and the like. And last, in order to be an equal member of the IEP team, you need access to information in advance of the meeting. So they have to provide you whatever they're going to be speaking out at least 3 days before the meeting. But in practicality, certainly both the family and the school can be sharing information beforehand. Here's what we're going to talk about and what we're going to address. So I referenced this, but establish a baseline. So what was the student's present level before all of the impacts occurred? So we need somewhere to look back and where a kiddo was, and then where they are now, or where they should be now. And the IEPs, hopefully, if they're written clearly and robustly way back when, then they will have expectations about where a student should be now. Okay, and another tip, compare the baseline information to expect. Okay, I already said that, I guess. Was there regression? So regression is a part of the discussion, but as Atlee highlighted, that's not the end of the story. Regression might have happened writ large, but where do we expect the student to be now? Was there increased difficulty in accessing and progressing in the general education curriculum? Yeah. So these are just kind of questions to think of, to ask, to propose to the team when you meet. Discuss and determine impacts of COVID-19 disruptions, and discuss services needed to fully address those impacts. So that, the compensatory education discussion. Consider recovery services to be provided to all students, access accommodations. So, we're not going to get into masks, as Atlee said, but when you think of something like if a mask was something that needed to be accommodated to access in-person education during the COVID pandemic, and that's going to be continued to be a requirement during summer recovery times. Okay, let's talk about that accommodation. What needs to be provided so that they can access that. Consider additional compensatory education and determine how they'll be delivered. Yeah, that second part is important. There might start to be many IEP teams that become well versed in how to talk about compensatory education and how to determine what's needed, but the delivery is really where it counts. And so we don't want to flood students that can't access that extra time right on top of their day. So let's say we're back in full time, 6 hours a day in fall 2021. An extra hour on top of that day might be unreasonable. It might be too much for a kiddo to handle. So it's got to be something they can access, whether over the summer breaks, etc. Consider whether additional services are necessary in the IEP going forward to provide a FAPE. So that's just that basic FAPE question. I would imagine that's where the team should start talking anyways, and just say, okay, let's just pretend we are meeting this kid for the first time, and what do they need in their IEP to have an appropriate program? Let's make that's their IEP. Now let's look back, let's see where they are and talk about that. So that's how I would approach it. Okay, great. So that's all the content we were going to share. Here's our contact info again. And you can contact, as Atlee said, you can contact either of us for general information if you're a provider. If it's about an individual kiddo, that goes for today as well. I've seen some very specific questions about people's own children. Those would be more appropriately sent to us through intake. See if we can help out in an individual level. And it looks like we've got at least 5 minutes left. So I'll kick it to Carrie and see if she's got some questions.
So we've got 3 right now to cover, 2 from before, but I want to start with the most simplest right now. Is it appropriate for schools to require parents to be an e-helper to keep their child focused and make progress on a virtual class, essentially being the ed tech for the student?
So if I understand it, they're looking back at the previous year and saying the kiddo would have normally had a one-on-one and they did not.
So basically it's virtual learning and the school is requiring the parent to be present during the virtual learning in order for the student to engage. So if the child was in school, they'd probably have an ed tech for support. And because ed techs aren't being provided at home and the student's not able to engage virtually, they're asking the parent to be that person.
Yeah, I would kick it to the team. It sounds like if the student has progressed as the IEP team has expected them to, and they're doing really well, and they're meeting all their goals, that might just be a discussion about how appropriately to go forward. But it's going to probably be more the case that if that parent wasn't able to provide the same level of service that the one-on-one was providing, that the appropriateness of the service was lowered. So, I mean, just anecdotally, it doesn't seem appropriate to depend on the family during that time, but that was largely what was expected across the board of all families, to just to facilitate the kids' attention in some way. But when it starts to affect a kid's program, that's when I would be concerned. So I don't know, Atlee, if you.
Yeah, I mean, it's, I mean, there's the answer, and then there's the answer, right? I mean, it's to some degree, if a family can provide that support, and then they should. Is it appropriate for schools to rely on it? No. I think that there are going to be a lot of the compensatory education claims, that from what's happened over the last year, that are really related to that, to this drawing a line in the sand, and we're not going to provide any sort of we're not going to provide access to in-person instruction, and we're not going to provide the support that your child needs to access the remote instruction. And there are, more than a handful of cases I'm aware of where, like, everybody knew that without in-person supports, the child wasn't going to access FAPE. And the parents said, we don't care if it happens at school or if you send them into the home, and neither happened. And so that's just, they're going to be, there's going to be a significant liability for compensatory education there. Hopefully teams are fixing this, going forward, as restrictions start to loosen a little bit and relax again. But, I think the parents that stepped into that role, did what lots of other people were doing. And if they did it and it was successful, it probably wasn't appropriate that they were relied on, but, move forward, I guess. But if parents were begging for help and they didn't get it, they likely have some strong, and the impact was that the student, like Ben said, didn't access their education. They likely have some strong, compensatory education claims. And the IEP team should be involved and addressing that. And there were a lot of schools that were relying on other providers. It was like they were happy to have people in people's homes. They just didn't want it to be school staff. So there was, a lot of providers have been providing services in homes, safely for the most part, I think, for a while. But hopefully some of that's in the past, and it'll be dealt with through the lens of what we just talked about, and that the future provision of services is getting more, the schools assuming more responsibility of that.
It sort of segues into the next question, which I think you've covered a bit of the answer to, Atlee. If there's a student that was considered truant because they were unable to access any of their virtual education, and the schools basically said that they would deal with it as soon as they're able to get them back to school, can it be expected for that student to re-engage with a special education plan? Or, I mean, we really need to look at compensatory education in that case, do we not?
Yeah, well, you could have to look at a lot of things. And I think where we ended up and where Ben emphasized is probably the place to start on that, is assume that student just moved back into your district. What do you need to do to get them to school and get them appropriate programming going forward? Then on top of all that, if we knew that that child couldn't access their education, and not only did we not fix the issue, but we referred them to, court for it, then, that there could certainly be some compensatory education there. But the real issue and the starting point is, how do we get re-engaged, starting now, and then looking in the past, and how do we, make up for all of this lost time and failure to make expected progress.
Great. I've launched the poll. We do have another question that I'd like Ben to speak to, just because I know he handled the systematic complaint in regards to CDS. And if he could address that, and if while Ben is addressing that, that'll answer the earlier question about CDS. If you could take some time to complete the poll, that would be wonderful.
Thanks, Carrie. Yeah, and we did say we were going to hit that. I think we actually didn't include the slide. But what was the question? Can you just reiterate again? What was the question about? So I think I know. So CDS said across the board, we're closed for in-person, it's April 2020. And then they reopened in May saying that you can provide remote now, something like that. Is that?
Yeah, so in other words, there was so much, I mean, when it closed, there were so many missed services that there would be no way to make compensatory ed up with the remaining time this year. And this child happens to be aging out of CDS and transitioning to kindergarten. And so what would be the plan for that when there were so many missed services? There's no way for the district to make it up through, or the preschool or CDS to make it up through compensatory ed before the kid would start kindergarten.
Right. Well, they should try. I wouldn't give up. You know, CDS is potentially liable for some compensatory education if they weren't providing a FAPE during that time. So I know that there were these gaps of time where a school was truly just closed, or CDS said we're not doing anything for this period of time, but those were relatively short. I know that for CDS, I believe it was really just a month or so. And I know to do with that individual case that I mentioned earlier in the presentation, and then to do with the systemic CDS York complaint decision, they both looked to that time period and said, okay, maybe initially in March there was some kind of closure, but then in April, this particular kiddo and many others like them were being offered remote instruction at that time. And that needed to be individualized. They needed to have access to that. And so the team needed to have met, and it needs to have been an appropriate program. So asking teams to meet and look back at that time and talk about compensatory education, that can be done anytime, you know. So that's just because CDS is phasing out doesn't mean they're not potentially on the hook for.
And can I say one thing to that? Is it just the same for CDS, and also if someone's graduated or aged out of services, there's not a bar on receiving compensatory education after those events. So whether you're transitioning into the public schools responsibility, or whether you're transitioning to post-school activities, if you had claims over this past year to compensatory education as against CDS, they wouldn't go away just because you're in kindergarten, or they wouldn't go away just because you aged out of services. So those things are still potentially viable. Now, whether you want to seek them is a totally different question, right?
Right.
So it would, if your child's aging out of CDS and going to kindergarten, the compensatory services would then follow upon the district, the local district, as opposed to CDS?
No, CDS, but CDS could deliver them. I guess what I'm saying is
in the kindergarten setting.
There's not an artificial stop point either in the transition to kindergarten or in the transition to post-school activities that would put an end date on when compensatory education could be provided. The end date is on when did you accrue a right to potential compensatory education, and the provision of that can happen after. And there's pretty clear, authority for that on the transition age students. And I don't see why it would be any different with what's, kind of an artificial transition, into kindergarten. CDS would be responsible because they were responsible at the time that the child was denied a FAPE, would be the argument, right?
And
so you're saying at least CDS would provide the compensatory services in the kindergarten setting?
All I'm saying, and the team would need to figure out what compensatory education services were even required, how they could be provided. I'm just saying that there's not to think about the first day of kindergarten as a date at which the child could not receive any of those compensatory education services isn't accurate. Now, whether CDS decided to provide them themselves with their contracted people, or contract with the school to provide them, or just have the family be able to go to an outside provider, those are all questions I can't really answer. It's just nothing magic happens when this child starts kindergarten. If they are owed compensatory education, they can still continue to receive that for a number of years if that's what people decided, so there's no legal bar on it.
Okay, thank you.
And I was just going to say, practically speaking, it might be that transition has occurred in terms of who's responsible today. And so if the family said, I want an IEP meeting with CDS, remember I was connected to you before, CDS might say, well, we're not going to have an IEP meeting. Well, then you can utilize the dispute resolution. Maybe a mediation would be appropriate.
Got it. All right, and I'm not, hold on, we have one more message. Okay. I am not seeing any more questions, so I want to thank Ben and Atlee so much for their time. I'll keep the poll posted for just a few more minutes. I think there was an error when I launched it the first time, so I relaunched it. If those of you that are still around could take a few minutes to complete that, that would be great. Again, thank you so much, Ben and Atlee, for your time today and in the past, and we look forward to continue to work with you in your agency and to help families in Maine. We will get this posted as soon as possible on our Facebook site and our website. And when Ben and Atlee provide us with the updated slides, we'll get those posted as well on our website. So with that, I will stay on for a few more minutes to complete the poll, but thank you, Ben and Atlee, and I hope everybody has a great day.
Thank you.
Thanks so much. Bye, everybody.